Hi, good morning or good afternoon, depending on the time zone that you are in. We are in Mountain Time. I'm here in El Paso, Texas. I am Natasha, and I will share with you a little bit of our background fighting or contesting NTAs. When we talk about our experience contesting NTAs, we have to talk about what I call two eras. Before Tornillo Emergency Reception Center and after Tornillo ERC. Before Tornillo, legal representatives here in our unit were not used to object either the NTAs or service. They used to admit the allegations and concede removability and move on with the case. When Tornillo opened in 2018, there was this agreement between ORR and DHS about not filing NTAs for the children detained in Tornillo, since it was a ERC and they were not being for a long time. At some point, DHS began to file hundreds of NTAs for those children. We had over 50 children a day with court hearings happening from Monday to Friday. In the before Tornillo era, at the first hearing, we appeared as friend of court. But then EOIR and DHS were using us as friend of court to cure the defective NTAs. When we entered appearance in the second hearing, and object the defective NTA following Pereira versus Sessions, DHS replied that as per Bermudez Cota, it was cured when they gave us all the notices of hearings for all the children placed in the docket on that previous hearing that we appear as friend of court. We received that same day hearing notices for the hearing on that day and the hearing notices for the next master calendar hearing. We then refused to receive the hearing notices and EOIR began to send them by mail to Tornillo, but Tornillo did not have a postal address. So children were not receiving the NTA or the hearing notices. The issue with the court hearing notices made us rethink our appearances as friend of court. We were objecting the NTAs to preserve the record, even when the immigration judge handling the juvenile docket did not grant our objections. I remember even having my own screen for the objections and DHS complaining and asking for more time to reply to my objection. We kept making objections and contesting NTAs as we do currently. Now Imelda will talk about the legal aspect and give some guidance on how to contest the NTA and service.
Thank you, Natasha. Okay, so now we're going to talk about how to spot a defective notice to appear and also kind of the strategies on how to contest them. So there's different objections and there's different ways you can contest a notice to appear. You can have objections based on insufficiencies to the notice to appear or otherwise violations to mandatory claims processing rule of INA section 239A1. You can object based on improper service. You can also require DHS to meet their burden, which isn't really an objection, but it's a good way to, sort of fight back. And recently, we've been speaking with other attorneys and other attorneys have pointed out there may be possible objections based on a new case that came from the board, I think a couple of days ago, matter of Morales that we'll be speaking about. Okay, so when we're talking about objections based on an insufficient NTA, kind of where do you, to kind of give you context of where all this comes from and where matter of Fernandez came from. You want to look at how does a lawsuit commence? How do removal proceedings commence in immigration court? And you can go to the Code of Federal Regulations, 8 CFR 1239.1, and that'll show you that proceedings commence by filing a notice to appear. And so in the evolution of litigation, we needed to know, well, what exactly is a notice to appear, right? Because that was the whole sort of argument kind of behind Pereira. And then in Nis Chavez, the Supreme Court finally came down and said, well, a notice to appear pursuant to INA section 239A1 is a single document provided at a discrete time and containing all of the statutorily required information. So in other words, a notice to appear has to be one document that contains all of the requirements in INA 239A1. And so if you go to INA 239A1, it's going to tell you that a notice to appear must be in writing. It must specify the nature of proceedings against your client. It must have the legal authority under which proceedings are going to be conducted. It must give notice to your client that they can be represented by counsel and that they can be afforded at least 10 days to secure counsel after service of the notice to appear. And notice to your client that they must keep their telephone number and address updated with the court and the consequences of the failure to do so. And importantly, the time and date and place where proceedings will be held and the consequences of failing to appear. So it's really important when you're looking at a notice to appear, especially if you represent children that are detained in ORR custody, to make sure that the NTA filed with the immigration court is complete, that it is all 3 pages. Why? Because the pages usually where we don't have the allegations or the charge of removability contain all of the other information that's required by INA 239A1. And so under 239A1, if any of that information is missing, you have a grounds to object. Why? Well, because in matter of Fernandez, after a lot of fights in the circuit courts, the board finally came to their senses and recognized that INA 239A1 is a mandatory claims processing rule that has to be enforced if an objection is raised. And in that case, we learned that an objection is considered timely if it's raised prior to the close of pleadings before an immigration judge. And you might ask, well, what is the close of pleadings? Well, that's to be determined. Our advice is raise the objection at any time that you see it, right? That it needs to be raised. We're pretty fortunate in our cases that since most of the children we represent are detained, we are their first counsel, we're there at their first master, but you may be representing children that have already had 2 or 3 proceedings. Doesn't matter, raise your objection, right? Because you always want to preserve your record. And so if you do timely raise an objection, matter of Fernandez says you don't have to show prejudice to your client. It's enough to tell the judge, Your Honor, there are deficiencies here. And typically the deficiencies we're talking about are that the notice to appear is lacking time, place, or date of proceedings. Now, it's an open question as to what exactly happens if the objection is not timely raised. Do you have to show prejudice? We don't know. That's to be continued. However, if you go further, matter of Fernandez also states in its holding that an immigration judge may allow DHS to remedy a non-compliant NTA without terminating removal proceedings. Okay, we are of the belief that there is actually no way DHS can remedy a untimely notice to appear. And yesterday, as a matter of fact, this very issue was taken up in oral arguments before the Board of Immigration Appeals. So we should be getting a decision soon on what the appropriate remedy is once you raise the objection to a notice to appear. But for today, we'll go over ways to kind of fight back when DHS puts forward their quote unquote remedies to these kinds of objections. And so we believe, we should always argue for strict compliance with the statute, right? That's essentially what Ms. Chavez and Pereira came down on, was strict compliance with the statute. If you read those 2 Supreme Court decisions, there's a lot of discussion about the language. And so we should be arguing the same thing, right? The NTA is no good if any of the information required by INA section 239A1 is missing. So you want to try and raise these objections as early as possible in proceedings, just to try and avoid getting into arguments about, was it timely raised, was it not? I think the earlier you raise them, the better. Okay, so what other objections can you make? You can also make objections based on improper service. So if you look at the Code of Federal Regulations at 8 CFR 239.1b or 8 CFR 1239.1b, service of an NTA shall, right? It's mandatory language, shall be in accordance, and we're back to INA section 239A1. And so if you go read INA section 239A1, it says, in part, written notice in this section referred to as a notice to appear. And then again, we see mandatory language, shall be given in person to the non-citizen, or if personal service is not practicable, through service by mail to the non-citizen or to the non-citizen's counsel, if any. So here, the line of argument that we use is that our clients must be personally served pursuant to the statute, and that personal service is in-person service, right? That's the plain reading of the statute. I think right now we'll talk about how DHS sort of fights back on that argument. But again, this is a strict reading of the statute. I think if you it's a plain reading of the statute, you see that the government is only supposed to evade personal service if it is not practicable, or if personal service is not practicable, then serve it, through service by the mail or to counsel of record. So I think it's really important when we're talking especially about children in ORR custody to really put it to DHS, right? To place the ball in their court to defend, well, why wasn't it practicable for you to personally serve our clients who are in your custody? They are in government custody. Why couldn't you get them personal service? Why did you serve the shelter instead of the child? Why are you trying to serve me as their counsel instead of the child? So that's another objection you can raise based on just the lack of actual personal service if it was mailed to your client or if it was given to the shelter. Of note is that the regulations actually speak to when a child is under 14 years old. That's the regulation at 8 CFR 103.8 subsection C, subsection 2(2). Service shall be made on a person with whom the minor resides if the child is under 14 years of age. So sometimes you'll get pushback from the government saying, well, we serve the parent and according to the regulation, that's good enough. Or we serve the shelter where the child lives and according to the regulation and case law, that's good enough. But again, you want to insist on a strict reading of INA 239A1 and essentially argue, well, the regulation though is going further than what the statute allows, because the statute is saying there has to be personal service unless the government can argue why it's not practicable for them to serve your client in person. Okay, and so the other way you can sort of contest an NGA, it's not really an objection, but it's more of a refusal to plead. And you're refusing to plead based on the fact that, well, it is first the government's burden to prove your client is not a citizen. It is their burden to prove that they are their alienage. And so for this, you just don't plead until DHS has met their burden to establish that that your client is a foreign national. And the authority for that is found at 8 CFR 1240.8C. I will be honest, that is like when you tell the judge that, you'll be like, Your Honor, respectfully, we don't want to move forward until DHS has met their burden of proving alienage. And usually the judges will ask you, are you claiming that your client is a United States citizen? And of course, your answer is going to be, Your Honor, I'm not claiming anything until the government has met their burden of proving that my client is a foreign national. Okay. And so there's been a recent case called Matter of Morales out of the BIA. I think it's a couple of days old. And essentially, this case is not really about NTAs. This case is actually about a late filed appeal and whether or not the board had was precluded from hearing the appeal due to the late filing. So the board was considering 8 CFR section 1003.38B to determine if it was a jurisdictional statute, meaning that if you missed the filing deadline, there was nothing they could do in order to accept the appeal, or if it was a mandatory claims processing rule. Long story short, they held that 8 CFR section 1003.38b is a mandatory claims processing rule, and that it has to be strictly complied with. But it is subject to equitable tolling if a party can show that the party has diligently pursued their rights and extraordinary circumstances prevented timely filing or compliance with the rule. So why are we even talking about this case? Well, we're talking about it because we feel like, right, in this case, the board was talking about a mandatory claims processing rule and the need to strictly comply with those rules. And in this particular case, they held, well, you can get around the strict compliance if you, as the party who's challenging the rule, can show that you diligently pursued your rights and that extraordinary circumstances prevented timely filing. So we believe we should try and start objecting, right? And placing the burden on the government to show, well, INA 239A1 is also a mandatory claims processing rule. So did you, government, diligently pursue your right? And what extraordinary circumstances prevented you from actually filing a correct NTA in the first place, right? Because as we'll see right now, Daniela will be talking about this, but at any time prior to filing a notice to appear with the court, the survey, right? The government can supersede whatever NTA they provided to your client initially and actually provide them with a fully compliant notice to appear prior to filing with the court. Okay, so you make your objections, and if you're lucky, DHS in your jurisdiction is not going to fight back. They don't do anything. And if they don't do anything at your next court hearing, what should you do? You just say, Your Honor, I want to move for dismissal based on lack of prosecution. You know, especially when we're talking about you've raised a matter of Fernandez objection because there is no time or date to the notice to appear. You can point back to the case and tell the judge, well, yes, Your Honor, the Board of Immigration Appeals says that you can give the service time to remedy, but they haven't remedied. And so you should dismiss this. You should dismiss this matter because it is still an outstanding objection. If it is a good judge, they will do it. And if it is not, they'll give DHS a chance to cure. And so what are some of the quote unquote remedies that DHS is trying to do? Well, when we're talking about deficiencies with INA 239A1, and usually we're talking about deficiencies as to time and date and place, what they're going to try and do, sometimes it varies. So practitioners have seen different things. They've tried filing new notice to appear with the missing information put in. The problem with that is that you can only have one notice to appear at a time. And the dissent in matter of Fernandez actually pointed this out. You can't have more than one operational notice to appear in a case at one time. So then what else does DHS try to do? Well, they try to quote unquote amend a notice to appear with a pen and ink change. Sometimes what this looks like is they'll file a motion to amend where the cover page says motion to amend, but then there is no legal argument. They just attach the exact same notice to appear that they had served on your client, but instead of a place to be set and a time to be set, they cross it out with a pen and write in your client's next hearing date and say, well, that's enough. Or sometimes what they've done is they've filed forms I-831, which is the continuation page for the notice to appear, or form I-261, which are additional charges to an admissibility or deportability. And through the filing of these forms, DHS tries to establish that time and date are factual allegations. Okay, so why don't any of those remedies work? Well, they don't work because there's no authority for them. The reason they try to couch time and date in terms of making them factual allegations is because really the only authority the government has to amend a notice to appear comes from 8 CFR section 1003.30. And that regulation speaks to DHS's authority to amend an NTA, but only as to factual allegations that inform the charges of inadmissibility or deportability. Okay, the issue is though, time, place, and date are not factual allegations that inform charges of inadmissibility or deportability. And even in a jurisdiction as backwards as El Paso, our judges have agreed with that line of reasoning. They said, no, that is not a proper cure. The time and date are not factual allegations. But what about the pen and ink changes? Well, the pending changes, our judges have said, yep, they're good enough, but with no legal authority. They've sidestepped the issue altogether as to whether that's allowed. Again, if you look at the reg doesn't speak to amendments to time and date, that DHS can do that. As a matter of fact, if you look at INA section 239A2A, and then its regulation at 8 CFR 1003.18B, it does speak to amendments to time and date on the notice to appear. However, Ms. Chavez addressed INA section 239A2A and said, okay, that statute is not operational though until you've actually served a compliant notice to appear on a respondent. And so, and that statute speaks to the immigration court changing the time and date, not the government. Same thing with 8 CFR 1003.18B. 8 CFR 1003.18B was actually the regulation that was being used by the immigration courts to justify issuing the notices of hearing, and why they had the authority to change time and date. But if you just look at that statute, or I'm sorry, the regulation, what you'll notice is there is no authority vested in any of that to DHS. The authority is vested in the immigration court. So again, when you're fighting back as to these remedies, at least until we get the board decision that lets us know how they're coming down on this, hopefully they'll come down correctly and say, all of you practitioners are correct. There is no authority given to DHS to cure as to time and date. These are, this is kind of how you can fight back. All right. So then what happens when you raise your objection as to defective service and the court agrees? Yes, there has been defective service here. Well, DHS may actually try to serve your client in open court. And so when that happens, you want to insist that the notice to appear must accurately reflect service, right? So you have to insist that your certificate of service has to be properly filled out, right? Because a lot of times what the government attorney is going to want to do is just say, here's the notice to appear, but the notice to appear is not correct. It's going to have the certificate of service from when the notice to appear was issued by a CBP officer or an ERO officer. And so you want to remind the court, like, this is not the correct NTA. Now the NTA is deficient because it's not a singular document. It doesn't accurately reflect right proceedings. So that's one argument. And so what can happen in the back and forth that we've seen? So DHS sometimes, though, when you raise the argument that, well, there wasn't, service wasn't proper because it wasn't in-person service, like I'd already mentioned, DHS will sometimes say, no, it was sufficient because the notice to appear was given to the shelter or the parent or counsel, or it was mailed. And why do they do that? The reason is because the regulations actually define personal service as including mail and that kind of thing. But again, you want to redirect the court back to the statute, right? Because what governs is the statute. The statute carves out mailing from in-person service. And so it's a really technical, right, finicky argument, but we just never know what might stick, okay? I'm not guaranteeing you that we're going to win in front of the immigration judges when we make these arguments, but we never know what might stick. So it's good to make our records for later appeals. And so again, we always just want to put DHS, to their burden. Why couldn't you serve our clients in person? Especially when our clients are detained in your custody, you know absolutely where they are. Or let's say your client was released. Well, typically your DHS knows their address. So again, why couldn't you serve the child in person? The regulations are the only ones that speak to service on a child under 14. And so service has to be made on the person with whom the child resides, and that includes the shelter or family member. I would still argue in those circumstances that the child also needs to be served with a copy of the notice to appear. Okay, and so what do we do when we raise, we say, well, DHS, you need to meet your burden and prove that our client is a foreign national. Well, typically DHS will file an I-213. And the form I-213, the reason you want that is because it'll actually give an account of how your client was interdicted either by CBP or ICE, and give the government's version of what happened. When this happens, you always want to ask for a continuance, not only to review the actual I-213, but you also want to speak with your client about the circumstances under which the information was obtained, right? And the reasons for that is because the I-213 is going to be considered an inherently trustworthy document. And so if you're going to contest any of the information there, you're going to want to take your time to look for any sort of inconsistencies in the document. So for instances, you're looking to see, is your client's name correct, their date of birth, their facts, their circumstances, anything like that, right? Are their pronouns correct, right? Is their nationality correct? You're looking for those inconsistencies, but you also want to interview your client to ensure there wasn't any undue force or coercion when they were questioned by DHS, because if there was, that may rise to grounds of filing a motion to suppress the 213. The other thing that DHS might do, or even the immigration judge, is try to get your client to admit alienage of the record. They'll say, well, just bring your client on the stand and we're just going to ask them. Object immediately, right? And the reason you want to object is the client can choose to remain silent, and DHS cannot use your client's silence to establish a prima facie case of alienage solely through inference drawn by their invocation of Fifth Amendment assertion of silence. These aren't criminal proceedings, but you want to throw that out there and cite to matter of Guevara as to your client's ability to remain silent on the subject of their alienage. Okay, so now Daniela is going to talk about notices to appear and kind of what this all looks like in practice, the different types of notices we've seen.
Thank you, Imelda. So now we are going to put some of this into practice. And we have a couple of different NTAs we like to share with you. As my colleagues already stated before, you want to make sure you have a complete NTA, all 3 pages. But for the purpose of this presentation, we will be focusing on the first 2 pages. And you want to make sure you request the NTA ORR has on file, because it might be different from what was filed with UIR. And so our first NTA here was provided by a case manager. And as we can see here, this NTA does not have an address under the client's name, right there. And then if we go to the bottom where it says the place to be set, a date to be set, and a time to be, this is a defective NTA because it is missing this information. And we'll now focus on the certificate of service on page 2, because you want to double check the date that the NTA was served. And you want to make sure you talk with your client and ask them if they actually did refuse to sign this document. We found that at times the government will just rubber stamp the NTA with a refuse to sign, meaning, it just may not have been served on them. So you do definitely want to talk to your client about this. And we're now going to go to the NTA that was filed with EOIR. So it's the same NTA. And this NTA does not have an address. It does have an address under the client's name. But if we look to the bottom, this NTA has a court date, a court address, but it's still missing a date to be, a date to set, and a date to be. So this is still defective. And again, we want to focus on the certificate of service on page 2, because there were no apparent changes other than someone else signed for it. And you want to make sure you talk with your client and ask if they ever saw this NTA, if they recognize the signature, because your client might not have been served. So we're going to be seeing a completely different NTA now. This NTA was also provided by a case manager, and this NTA does not have an address under the client's name, right there. And then we go to the bottom where it says a place to be set, a date to be set, and a time to be. Based on what my colleagues have previously talked about, this is a defective NTA. And remember, you want to check that certificate of service. And you also want to check that if it was refused to sign or who signed for it. And now we're going to go to the one that was filed with UIR. And we redacted this NTA, but we added the pen and ink change to reflect the actual change that was made on this NTA. And as you know, my colleague talked about the pen and ink changes. This is what they might look like. Someone wrote in the shelter address and a phone number. And at the bottom, you may also find a date to be set and a time to be crossed out with the date and a time just penciled in. Oh, I'm sorry, could we go back to the other one? Okay, definitely. And you want to check that certificate of service because you want to check if this was actually served on your client, these pen and ink changes. And in this case, the certificate of service stayed the same. So you want to be able to object to that. Okay. So now we have a superseded NTA. This third NTA was also provided by a case manager. And just like my colleague said, something to really note is that DHS can supersede unfiled NTAs. So you want to make sure that the NTA your client was served with is the same one that was filed with court. And because this superseded NTA is supposed to be this document that has all the information, all the mandatory information that the previous NTA didn't have, it was basically redone. So we're going to go ahead and go to the next one. Okay, so now we have the one that was filed with court, and we still see that it's defective because it's missing the date and time at the very bottom. So you do want to go ahead and object to these as well. And lastly, we wanted to include what an I-261 looks like. In this case, DHS tried to establish time and date as a factual allegation. And as my colleague mentioned, you want to object to these. So now I'm going to go ahead and pass it over to Natasha.
Thank you, Daniela. So it is important not only to be prepared as legal representatives, but also to prepare the client and explain to them the importance of the NTA and objecting in a timely manner to preserve the record. I explained to them by comparing their cases with a house. And I told them, I tell them, to have a solid house, it needs a good foundation. Well, the same goes for their cases. I tell them that they are my boss and that the government has to do its job well. And in these cases, mostly on NTAs, they didn't do a good job or what they are supposed to do. It is their right to object if DHS job was not done well. The NTA and making those objections on time are the foundation of their case. If they agree to object, it is important to tell them that perhaps our tone of voice could be different, that we'll be speaking in English, explain that if the judge does not give us the reason granting our motions at that time, not to lose hope. That does not mean that the case is lost. We may have lost the battle, but not the war. So now we have time for questions.
Hi, Natasha. We have a couple of questions in the chat. So the first one is from Oscar. If you don't receive the court location, like the first example, what is the best practice for filing a change of address with EOIR?
So if you don't receive the court, so on the notice to appear, there is no place. I would say prior to seeking to change venue, it sort of depends on your court, but it might be a good idea just to go ahead and object altogether. So depending on your jurisdiction, some judges are really good about once the objection is raised, they may move to terminate right there and then. So you kind of have to, it's based on your local practice. But when you do see those deficiencies in your counsel of record, my advice would be object first to the violation, like noting the violation, wait for a ruling on that. And then if it goes your way and DHS doesn't remedy, great. You've got proceedings terminated for your client, but if you don't want to terminate proceedings, then the best way would be just to file your E33 through ECAS.
Thank you, Imelda. We had another question from Malika. For kids that are detained under age 14, if the NTA does not have any signature on the certificate of service, is the NTA defective?
It's not necessarily defective, but it does show it's going to be hard for the government to prove service on your client, right? There's nothing there showing how are they going to prove service. So there you'd want to object based on service and saying, there's no proof that my client was served. There's no signature on here. And so if the little box is marked in-person service, well, there's no proof of that. So you'd want to raise the objection and say, well, Your Honor, I object. Service is not proper. There's no indication here that my client was actually served, and put DHS to their burden to see how they answer to that.
Thank you. And we have another one. How can I obtain an NTA before a hearing? When I request ORR records, sometimes it's not on the PDF that they send.
Can do that, asking the case manager of the child to send the NTA, because otherwise then you have to enter a appearance to have the NTA filed with court, which could be different from the one that the case manager is going to share with you, as Daniela explained before.
We still have some time left, so enter any additional questions you have in the chat.
We have another question in the chat. As a practical matter, to review the immigration court's NTAs, is it best to make an appointment with the court to review or by EOIR FOIA?
I think that's also probably going to depend on your local practice, but it's usually faster if you just go in person to your in your court. And if you have a good relationship, right, with your court administrator, usually you can see the file that same day. I think in our court, at least, they usually do require us to do an E-28, but you can note in the notes section of the E-28 that it's for the sole purpose of reviewing the FOIA, that you're not entering your appearance in the case. And so you can do it that way. And usually most of the courts also have, it's a new EOIR form, which I can't think of the form number now, but that you can present at the local court and to actually see the file that same day.
Thank you, Imelda. We have a couple of more questions coming in. Thank you, everyone. These are great. So we have a follow-up to the first question. Lots of kids received defective NTAs without date, time, and court location. If you want to promptly enter a change of address, how do you determine which court to file that change of address with?
Maybe my colleagues can also chime in on this, but the best way would honestly just be looking up the child's A number in the EOIR portal and seeing where the case is currently docketed at. And if it's not docketed, then I can't think of a way to do it other than your client maybe having to do it pro se through clients can file changes of address at least online. But if it's not docketed yet, I don't know really. I don't have an answer for that. If it is docketed, you should be able just to look it up on the portal, and you'll see what court the case is currently pending in.
Thank you. Another question is, what are the objections that can be made regarding superseding NTAs or re-superseding NTAs?
So I recently received a superseding NTA, and I still objected because it didn't have the time and the date. And I also made the argument that this was a document that was supposed to be created with all the information and that it was properly served, and it still didn't meet it still didn't meet the standard for a complete document. So I still think you can object to those if the information is missing. And if you do get an NTA with those pen and name changes, you still want to make sure that you check for that certificate of service, because maybe your client didn't receive that, or you didn't receive that, and that's the first time that you're seeing it.
Thank you. And another question we have is from Rebecca. If the NTA says refuse to sign and my client says that they weren't served and didn't refuse to sign, what evidence do I use to prove that?
Their testimony. and Natasha might be able to speak more to this, but usually it's going to be their testimony. You may want to formalize it and have them write it out, right? So it's written testimony on the record, and then any sort of indicia you might have to, back that up. So if your child was at a shelter, you might reach out to the case manager and ask, did this child ever receive this document, and that kind of thing.
Yes, definitely. You can present testimony. It's gonna, once you contest the NTA, and if DHS doesn't have like a response right there and then, the judge may give them time and set a contested hearing. So then you can present any kind of evidence, testimony from the child, the case manager, if they are willing to do so. But you can, it's gonna be their word against the child words, but you can definitely object and present evidence.
I'll add really quickly, you might also just try and subpoena the officer, right? That's on the certificate of service. Those don't go well in our court, but it is a quiver that you have in your bow of arrows, right? And have the officer come and attest to that. That's actually what happened.
Another question we have is, what arguments, aside from service, should we explore if DHS starts proceedings by filing a superseding NTA that appears to cure the defects of the initial NTA issued at entry?
That's a very good question. And I'll be honest with you, I believe that DHS can supersede unfiled NTAs. And so to my way of reading the statute and the regulations, I do believe that as long as they serve that superseding NTA on your client, right? Your client has a copy of that notice to appear. If the notice to appear is complete, it's complete. And so I wouldn't have an argument for that, but maybe other practitioners here would. So I'd be happy to hear from others how they would address something like that.
Don't forget always to check the certificate of service. Maybe they superseded the NTA, but they kept the page number 2 of the original NTA. So you can always object service or proper service, because remember that the NTA is a whole document, so they shouldn't be making changes or superseding page 1 and not reserving the NTA on the respondent. So it's a whole document. You have to check everything and anything.
Thank you. We have a couple more questions in the chat. So the fact that a child is given the ORR envelope containing the NTA does not count as service by DHS, correct?
Sorry, could you repeat the question? You broke up on my end.
Oh, so sorry. So the fact that the child is given an ORR envelope containing the NTA does not count as service by DHS, correct?
That is correct. So unless it was the ERO officer, right, or the CBP officer handing that child the envelope, no, that would not be proper service.
And also, I would like to add that if you are before the judge and the judge give you a copy of the NTA just because the respondent doesn't have it, that does not constitute service. It has to come from DHS.
We have a question with regard to the testimony aspect that was brought up earlier. Doesn't putting them on the stand to testify about service open them up to questions about alienage?
That's a risk, right? Anytime you place your client on the stand. And so that's where Natasha's point of being prepared, right, really comes in handy. So you really want to walk your client through what will happen, because typically when you raise these objections, it's not going to all happen on the same day. Usually the judges are going to set it out for a contested hearing. And so you just want to run through your client. And if they do get that question, right, practice with your client saying, my counsel has advised me to not respond to that question.
Thank you. And another question and a clarification. When DHS says they are serving a new superseded NTA upon a child in court, that can only be true or effective if all pages of the NTA plus the certificate of service are included, correct?
Yes, and it has happened to us that DHS give a copy of the file NTA to the child, but then there's nothing, no signature, nothing in the service. So they have them right there, right then, and could ask them to sign the certificate of service, or going on the record and say, we would like to say that we just served, but that does not happen. So in the next hearing, you can object that.
It looks like the questions have slowed down in the chat, but I'll put out another call if you have any lingering questions on this really important topic. Please put them in the chat now. All right, well, I'm going to call it and say thank you so much to our three presenters, Daniela, Natasha, and Imelda. This is clearly such an important and timely topic, and we are really appreciative of your wealth of knowledge and for answering everyone's questions.